Welcome back to the DYK Media Podcast Discussion Series. My name is Richard Ford, and I'm your host. In today's episode, we have a very special guest, Peter Orr, who is the Deputy General Counsel for the National Labor Relations Board in Washington, D.C. Mr. Orr began his career with the NLRB in 1997 in Hawaii. Mr. Orr then became the Regional Director of the Greater Chicago Area's National Labor Relations Board office, and it was during his tenure in Chicago that he authored the decision in the 2014 Northwestern University football case. Mr. Orr then came back to Washington in January of 2021 when President Biden appointed him as acting general counsel. In July of 2021, Mr. Orr assumed his current role as the Deputy General Counsel of the NLRB. Mr. Orr began his education at Cerritos College in California. Then he received a BA in Business Economics from the University of California, Riverside. He then went on to obtain an MBA in Finance from Hawaii Pacific University, and then he received his law degree at Pepperdine University. Mr. Orr takes us on a tour of the National Labor Relations Act and explains its purpose, scope, and importantly, its underlying values. We also discuss two college sports-related cases that go to the question of whether certain classes of athletes are employees under the National Labor Relations Act. Mr. Orr explains what misclassification and joint employer liability mean and walks us through the life cycle of an NLRB case from the filing of a petition or a charge to the possibility of a case winding up in the United States Supreme Court. Whatever you think about employee status for athletes, this episode is an important resource for understanding how that determination would be made under the National Labor Relations Act. And just a quick note, our discussion occurred on March 10th of 2023. Enjoy. Good morning, Peter, and welcome to the DYK podcast.
Hey, Richard. Thanks for having me.
Yeah, I'm really looking forward to this discussion and truly appreciate you giving us your time here this morning. There's been a lot of discussion in the sports commentariat over the last couple of years about college athletes as employees of their university or certain classes of athletes as employee. And there are a number of legal and regulatory balls in the air to that point right now. And an important one runs through the National Labor Relations Act and the National Labor Relations Board. We're going to talk specifically about a couple of cases that provide context for that. But before we do, if you could help us demystify the NLRA for our viewers and listeners and talk at the 30,000 foot level about what the NLRA is, what its purpose is, what its scope is, and importantly, what are the values that underlie that legislation?
Yeah, I'm glad you asked because there is an act that's been around for 80 plus years. There's still confusion about what the National Labor Relations Act is all about. It was one of the cornerstones of the New Deal under President Roosevelt, in response to what was happening in the economy, workers and the imbalance in power at that time, and trying to recover from the Great Depression. It ultimately is a law that provides for employees to have a voice at the workplace. And that voice may become a unionization, represented exclusively by a union for your terms and conditions of employment. And so we have a lot of cases involving unions. But it also is all of the prerequisite stuff, all of the predicate protections that are required if employees choose to be represented by a union. So it is having the status of an employee, having the protection of the law as an employee, having the right to be able to act concertedly with your coworkers about terms and conditions of employment, giving employees an opportunity to express their concerns, seek better working terms without the fear of retaliation. And that's a key important part of it, that they have a law that protects them from doing this. It doesn't guarantee that they are going to obtain what they are seeking, but it provides them with a voice. And we all know, and again, going back to the imbalance of power between employers and employees, we all know one employee's voice is easier to ignore than a group of employees. So that's why in the National Labor Relations Act, the Section 1, it begins with
Hmm.
encouraging collective action, encouraging
Right.
collective bargaining, because I think they recognize that the power of a group activity is stronger than individual. And in order for it to actually have impact, you need to have protection to be able to do so. I often say it is, the civil rights at the workplace. It's in many countries, as we know, labor law is a basic fundamental human right that is recognized within internationally labor rights as a human rights. In the United States, it's our human rights as they take place in the workplace. So it is that expansive. And the current general counsel, Jennifer Abruzzo, really, from the get-go when she was sworn in, has taken a real hard look at what the National Labor Relations Act was supposed to be all about from the beginning.
Right.
And where are we now? That was back in 2021. Where are we now?
Hmm.
Why is the act the way it is now? And how is it being enforced? Are we living up to the mission of the National Labor Relations Act? And so you'll see a lot of the initiatives, and from remedies to the broad reading of the act, being an attempt to recalibrate so that we are enforcing the mission of the act.
Yeah, that's so important, and that the voice, having a meaningful seat at the table, is so important. And you referred to Section 1, and it looks to me like Section 1 has two fundamental purposes. One is to provide labor harmony and labor peace through collective bargaining. And I think a lot of people, and myself included, have been under the misapprehension that collective bargaining means conflict, when in fact the purpose is to avoid conflict and provide labor harmony. And the second thing, to the values issue, Section 1 speaks in terms of freedom of association, workplace democracy, liberty of contract, self-organization, and being able to choose your own representative. And those are so quintessentially American.
And you say those out loud and you hear basic rights that we all expect outside the workplace,
Right.
right?
Right.
The opportunity to, in a democratic manner, select your representative, have a voice, be able to, under First Amendment, be able to associate freely. I mean, all of those things that outside the workplace, none of us would be shocked to, well, actually, we would be shocked if any of those things were taken
We're
away from
taken
us outside
away.
the workplace.
Right.
Oh my
Mhm.
goodness. I mean, but then all of a sudden you cabin that in the workplace, people aren't all familiar that those protections are actually there, but not in the Constitution necessarily. I mean, mimicked in the Constitution, but under the National Labor Relations Act, all those rights are there.
In terms of scope, like a lot of federal statutes, and this is a creature of Congress, you have a very broad statement of how it applies. The policy is as broad as possible. Then you have a very small number of exemptions under the act. So
Right.
you've got agricultural workers, domestic servants, family members, independent contractors, supervisors, and railway workers. And that's it. Students and student athletes are not specifically exempted from coverage under the act. Is that correct?
That's right. I mean, and again, I think when the law was written, it was written that you'll see that what was called the Wagner Act, often referred to as the Wagner Act. It's not a very long statute, and
Hmm.
is the wording of it is very broad, and the purpose was to include as many employees in the workforce, so that other than the exceptions that you read off, it is presumed that people are covered by the National Labor Relations Act. And in fact, if someone, a party is trying to exclude them for whatever exemptions, that party has the burden of proof to establish that that is the case. Otherwise, the presumption is going to be that these individuals are employees who are covered under the National Labor Relations Act. And I think that's what you saw when the board overturned Brown and went back to Columbia University and the college graduates employees issue, and going back to the language of the language of the act and the purpose behind the act. When the board, with the Columbia University case, said that the broad reading of the National Labor Relations Act should cover these graduate students and teaching assistants.
The other misconception, I think, that is a product of the way that some of the in-system stakeholders, the NCAA and the Power Five, have talked about this issue, is that the NLRA doesn't just go to financial issues. Importantly, it goes to work conditions and to issues of, health and safety, and importantly, having a seat at the table. And I think that, kind of makes the NLRA unique compared to some of the other legal and regulatory pathways, like the FLSA. This Johnson case has gotten a lot of attention in the Third Circuit. The FLSA serves a much different purpose than the NLRA, and the NLRA is not just about money. Is that right?
Oh, I mean, it is about terms and condition of employment.
Right.
It is what people believe to be important at their workplace. The culture, including harassment issues, how the job gets done, promotional opportunities, scheduling. It is much more, and I don't mean to diminish the importance, obviously, of the pay,
Right.
and safety measures. But when we all think about the quality of our work, we all know it's much more than that. And so it's the opportunity for, and actually, you raise this at an interesting time because your audience may be aware of so many of the other organizing efforts that are happening nationwide,
Mm-hmm.
from the Starbucks,
Mm-hmm.
Google, and it is being done by employees who are seeking higher wages and safety concerns, but also seeking other aspects that are tied into the culture of the company that affects their terms and condition of employment.
Right.
So, I mean, we've seen real life examples of that happening now. I think it's incredibly important, especially when we're talking about universities and individuals who are athletes, what it means to them as to it is not just financial, it is also everything else. And particularly, we know if you're an athlete, there are safety concerns,
Right.
long lasting life lasting safety concerns that may not be at the moment issues, but in the long term, it could be significant. And that's the unique aspect of the National Labor Relations Act, which really has drawn me to be with the agency for as long as I have, is because, as you said, it's not this kind of stovepiped into this little area of the law, wages or discrimination on this or work safety issues. It encompasses all of those issues. It encompasses all of the terms and conditions of employment, employees having the ability to be able to speak out, have changes made as long as they act in a concerted effort. So,
Yes.
and that really is the beauty of the National Labor Relations Act.
Yeah, and you raise a really interesting point. In fact, just this morning, I get a feed from the New York Times, and I got an article on the labor environment, not just domestically, but internationally. There's sort of a refocus on that now. There's a
Mm.
consciousness, I think, now that we haven't had in a while, and that does make some of these athlete issues timely, I believe. If we could transition into sort of a case study that can provide us some understanding of the athlete as employee issue, and then the process for running a case through the NLRB. And in 2014, the Northwestern football players tried to unionize, and they filed what's called a charge. I guess it's kind of like the complaint in a lawsuit, or what
A
initiates
petition,
a
actually. A
petition.
petition, yeah.
Okay. A petition to be recognized as a collective bargaining unit. But they first had to establish that they were employees, because the NLRA only applies to employees, and it only applies to private entities. Is that correct?
That's right.
Yeah,
So it applies to employers in the private sector.
in the private sector. Right. And Northwestern is a private university. And we'll talk a little bit more, about the complications there, because in the Power Five landscape, I think 52 or 53 of those schools are public. So there's some coverage issues there. But you were the regional director in the Chicago office. I think was that Region 13?
That's right.
Yeah. And you wrote the opinion after the hearing, the administrative hearing on that. If you could explain a little bit about what that case was about, and maybe mix the substance with the process, from the charge
Mhm.
to the evidence gathering to the hearing to your opinion, and then to an appeal to the national board.
So the National Labor Relations Board, we have two main functions: is the unfair labor practice cases that parties allege that are called charges. We're investigating for violations of the act, and then there are the representation cases there are petitions where employees are seeking an election, an opportunity to choose whether they want to be represented by a labor organization. And this is what happened with Northwestern with the latter. Initially, we've had some unfair labor practice charges filed subsequently,
Hmm.
but initially was the petition that was filed. And again, the initial question that came to us was a threshold question: are these employees under the act? And I will say, we had a long, and typically we don't have hearings on, because we know someone as an individual is an employee or not. Sometimes there's
Hmm.
questions about whether the individual is a supervisor and so on and so forth. But mostly those issues are resolved, and we normally don't conduct a hearing because the parties agree to and stipulate to the terms of an election. In Northwestern, the threshold issue was still in contest, so we conducted a hearing. It went for over a week,
Right.
and the parties essentially, prior to our having the hearing, essentially stipulated to all the facts, provided us with joint documents, which is why I think when I issued the decision, much of the facts were undisputed, and they were presented to us by both parties. So when we saw, how much people get earned, for scholarships, how many hours
Hmm.
the players are committed to the activity, what it meant with regards to their academic career. All of those factors were undisputed. They were stipulated to. And so once the hearing concluded, and reading the transcript, initially the thought was, at that time, Brown University, which the board had decided that graduate students, teaching assistants, were not employees. Initially, the thought was that Brown University decision would make it difficult for these football players to be considered employees. And the Brown University had a four-part analysis.
Hmm.
And looking, and you'll see that in the Northwestern decision where we go through the four-part analysis. And what became clear to me was that that four-part analysis is really irrelevant. It
Right.
really doesn't apply in this situation. So because being a student had nothing to do with with the individuals being a football player. The academic career was not tied in. They were there at the university, certainly,
Hmm.
like a student who's at a university and works at the bookstore, that
Hmm.
the student is an employee of the bookstore. But other than their being at the university, there was nothing tying them in together. So it seemed irrelevant to the analysis as to whether they're employees or not. So which then the default analysis, and it has always been the case, and again reiterated in the Columbia University case, is the common law test,
Right.
which basically looks at the control.
Hmm.
Are you providing a service, and is the entity controlling you? And from all of the facts, again, undisputed, it seemed clear a service was being provided, and a control was being provided by the entity over the individuals providing the service. That, I mean, in a layman's way of explaining what the common law test is. There some discussion about, what about revenue? What about profit? What about money?
Hmm.
That is not necessarily a part of the test. you could have an organization, which we do, right? And a lot of not-for-profits where they're not generating a profit.
I'm sorry. Does that common law test also includes payment? There needs to be some kind of compensation or payment.
Uh,
Yeah. And
Right. So,
and and that's important in the athlete case because the NCAA we're going to talk about Jennifer Abruzzo's memo and the use of the term student athlete, but the NCAA outright denies that the athletic scholarship, titled athletic scholarship, is payment for athletic services, and that the scholarship is, they call it a grant in aid, and they're standing by that characterization, in all the different forums where that issue is relevant. And could you talk a little bit about the importance of the athletic scholarship in that Northwestern case as payment?
so just to be clear, it's compensation,
Okay.
right? In any form. It doesn't have to be what we typically think in a biweekly paycheck.
Hmm.
It could be any form of compensation. And what we saw again in the record was these offer letters that were being made to the athletes,
Hmm.
and from having read thousands of employment offer letters in other industries, when I saw the offer letter from Northwestern going to the students, it seemed very clear that this was similar to an employment offer. It
Right.
had similar terms, and this is what you will be providing, this is what we'll be offering, and this is what you'll be getting in return, which is a scholarship. So it didn't seem like a great leap to have the analogies match up like that.
Yeah, I read that opinion. I've read it many times. I've also read the transcripts of the hearing that was conducted, and I don't know, in my judgment, it wasn't even a close call. I mean, when you look at the evidence and then apply it to that common law test, it just seemed like how could these football players not be employees? Did you see it that way, or did you think it was a kind of a tough call?
Well, I'll be frank, when the petition was initially filed, it was not your normal run-of-the-mill petition. So I had to take a step back, see what the petition was seeking. And again, the initial thought was, oh, you're going to have to apply Brown University and the graduate
Right.
students. And at the current board law at that time was that they were not employees. So how are these facts going to fit within Brown University?
Right.
But as you know, once the evidence came in, and undisputed evidence came in,
Right.
and you looked at the transcript, you quickly realized Brown University is not relevant, and then you quickly look at common law test, and it became very easy to make that
Yeah.
determination at that point.
Yeah. And you're talking about Brown and Columbia. So that's kind of a separate test, the statutory test. Brown was the law that was in existence at the time of the Northwestern case in 2014. Would a case like Northwestern now be governed by Columbia? Would that be a different test? And would that be applicable, or would you still go with the common law test?
I think it still would be with the common law test. In the general counsel's memo about athletes at higher institutions, it specifically talks about the Northwestern decision and the
Right.
common law test that was applied. Because I think it is inapplicable. The graduate student is a unique situation compared to athletes.
Right. So you had the decision, and then Northwestern appealed to the national board. Could you explain the difference between what happens at the regional level versus the national board, and then what happened with Northwestern at the national board?
Right. So in petition cases, the regional director has the authority delegated from the National Labor Relations Board members
Hmm.
to investigate and issue an initial decision, which was the Northwestern decision. And then parties can appeal that decision to the board members in Washington, D.C., and through what's called exceptions. And at that point, the board then has the jurisdiction to issue, which it did, a decision on the regional director's decision. And as we all know, the board issued a decision dismissing the petition, but made it clear that they were not touching the issue about whether the athletes are or are not employees. They were leaving that undisturbed for another day.
Mhm.
But the reason for dismissing the petition, that particular petition, was for more jurisdictional policy consideration that the board thought in that particular petition was not, for policy purposes, worth
Right.
pursuing.
Right. That's so important. Another narrative that's developed after Northwestern is that that national board basically said that athletes, as a matter of law, were not employees, when in fact they didn't address that issue, and those factual findings were not disturbed
Right.
by the national board, and that a lot of people think they kind of punted on it because of this, the composition of the Power Five. But I think it's so important for people to understand the exercise of applying that common law test, is pretty clear cut. And the national board has not said that athletes are not employees, or that the evidence didn't support a finding that they are employees. Is that a fair
Right. That's right.
characterization?
I mean, it's not even a characterization. The board could have issued its decision based on policy grounds, as it did, and
And
leave it at that. But they went one step further and explicitly stated in their decision that it's not disturbing the employee status
right.
question. I think that is explicitly what the board did.
Did. Yeah. Okay. So let's now press fast forward to September of 2021. And on September 29th of 2021, Jennifer Abruzzo, general counsel in your office, issued a guidance memorandum on athletes as employees. And in the very first footnote of that opinion, she said she wasn't going to use the term student athlete because it was really cover for a legal purpose that the NCAA used. And a lot of people know that Walter Byers invented that phrase in the 1950s to avoid workers' compensation liability. And she characterized the nature of the use of the term student athlete as a quote unquote misclassification of the status of the putative employees, and that student athlete's not the opposite of employee, essentially. And that's the way that the NCAA talks about it. Could you talk a little bit? And of course, I should back up. She also introduced the possibility that the board and the general counsel's office would be open to looking at joint employer liability, where a private entity, who is interstitial with the institution, like the NCAA or the conferences, could be responsible under the NLRA as a joint employer. Could you talk a little bit first about this misclassification issue, what it is, what it's not, and how it's relevant now as a segue into this USC case, this case pending on the West Coast?
So, Richard, I alluded to this earlier, but I think this is a perfect example of, Jennifer Abruzzo's coming into the position of the general counsel and really looking hard at what the National Labor Relations Act is all about. Employees need to know their rights under National Labor Relations Act. That's, we talked about that earlier. But once they know their rights, if they are being told that they are not employees, knowledge of those rights is immaterial because the act doesn't apply. The protection of the law doesn't apply to them. And if they try to exercise the rights under the National Labor Relations Act, those protections of not being retaliated is not afforded to them. So if that's the case, then employees are going to feel less confident. They'll be chilled in seeking to exercise those rights to obtain a seat at the table.
Right.
And that's what the misclassification really boils down to. And not just student athletes, and it was a obviously a conscious, deliberate decision, recognizing the history behind the term to frame it the way that Jennifer did. But it's the other statuses of someone a company classifying an individual as a supervisor, as you listed, that being one of the exemptions, right? Listing the individual as an independent contractor.
Right.
And again, if you're that individual and this label, this position has been placed upon you, whether you know the rights under the National Labor Relations Act, it'll be pretty hard pressed for you to start exercising those rights if you feel that those protections are not available to you. And again, these are basic premise kind of questions, but
Right.
important questions that will ultimately change whether individuals are going to seek the protection of the act, and why it is so important that we know knowing the history of the student athlete label, and that meaning, as you said, not an employee, that type of misclassification has a chilling effect on these individuals. And that chilling effect is a violation of the National Labor Relations Act. And there's been a lot of discussion, not just at universities and colleges, but
Hmm.
at the workplace, about why it's so important that we provide employees this protection, that they are not chilled from
Right.
exercising their right under the act.
Yeah. And,
And that's what this essentially is.
yeah, you make some important points. And because the athlete as employee issue has gotten so much coverage, people forget that that's just one piece of the puzzle on this whole misclassification issue. And it really was contextualized in the independent contractor scenario. But to the values-based point, the term student athlete has been insinuated over 70 years into the language and the culture of college sports. Athletes, I believe, this is my personal opinion, at the institutional level, believe that they don't have any protectable rights, and that they are fearful of even trying to organize. And the way these issues have been framed by the NCAA, the Power Five, and the media and corporate interests, the athletes feel like the student athlete just rolls off their tongue effortlessly,
Right.
and they don't really
Well,
understand what that means. Yeah.
that's exactly what I'm talking about. Is you know, it we all of society have already been preconditioned.
Right.
Here's the starting premise. And you operate from that starting premise. Student athlete means this,
Right.
right? And that's why I think it's been so powerful in the last 2 years of looking at whether the premise actually is grounded
Yes.
in the law, the mission of the act. And if you look at why the act was passed to begin with, because of the imbalance in power.
Hmm.
I mean, it'd be one thing if the employer and employee were on equal footing, right, to begin with. But we know that's not the case.
Hmm.
And then on top of that, have this misclassification, or the premise of the individual believing, and statutory employees do end up believing that they are not employees. And forget about athlete for a second, but
Right.
in the workplace, because it's been drummed into them, they've been told, in fact, sign a document that says they're not an employee. That imbalance of power is now increased that much more. So the individual is not going to seek the protections under the act. You bring that to the athlete's situation. I mean, I don't think we're going on a ledge by saying that imbalance of power may be even greater. We're talking about some of these athletes who are from underserved communities.
Yes.
One,
Yes.
we're talking about individuals who are by nature very young, right? And three, the potential of what is at risk. The potential. We know just a small percentage of these athletes go professionally, but even that potential of what is at risk, that causes the imbalance to be that much larger than even at other workplaces. So add to that misclassification, it's going to be pretty hard for individuals to then think, I have the protection under the act, regardless of everything that's else been stacked up against me. Right. So I
And
think that's why it's so important for misclassification to be a significant part of what we do.
yes. And again, that covers all industries. That's not just a college sports issue. It's a policy issue as well. One of the beauties of that Northwestern case, even though it didn't achieve its ultimate goal, was that there was actual fact finding on the label that the NCAA had applied. And the NCAA over the years has been very successful in litigation, federal litigation, in avoiding the application of fact-based inquiries. That's true in Johnson. They're essentially arguing for an immunity from a Seventh Circuit case so that there won't even be any fact-finding on whether athletes are employees under that act. And I'm not trying to conflate those two acts, but that issue is similar. The approach is similar, and that these athletes don't have any protectable rights because they are student athletes. And it's a crazy circular argument. And in Northwestern, the evidence, the real evidence, not the label, but the evidence and the facts of the relationship showed that, yes, indeed, they are employees. And I don't understand why people would object to that fact-based inquiry, to look at the truth of the relationship, but because they're so buried in the mythology. And I think that's one of the challenges.
Well, and especially, that's why it's stated earlier, when you look at the development of the record and the evidence in Northwestern, where the facts are stipulated.
Right.
Facts are undisputed, right? So no one could then say, oh, you're manipulating, this is not a fact, but it's an argument. These are the facts. No one disputes the fact. I did want to also, I remember you asking earlier, and I think we got kind of sidetracked about the joint employer. And as you saw in the general counsel's memo, who is an employer is also a premise question, right? And when we know that it's not just a university, but also a conference and the NCAA that have a role in what happens to the athlete. You know, we're currently investigating the USC cases,
Okay.
and so, you know, I can't talk about the determination on that, but we know that there is a role. If there's a role that would be enough to be a joint employer, that's part of the investigation. But the importance of all of that, though, is once entities are found to be joint employers, then those other entities that are not public entities may then, because of the National Labor Relations Act's jurisdiction, with only private employers, could then potentially fall under the jurisdiction of the National Labor Relations Act. Unlike at the Northwestern case, where the board made a statement about, as you said earlier, only a handful of universities are private, and especially in the Power Five. This could be something different because obviously the NCAA and the conferences apply all the universities.
And on that point, that joint employer issue has been presented in the Johnson case. And I don't want to conflate those two. FLSA law is completely different. But the district court judge, Judge Padova, I think he's in the Eastern District of Pennsylvania, he issued an order on joint employer and said the NCAA could be. He wasn't saying that they were, but he thought that the complaint alleged sufficient facts for that to go forward in discovery. And he emphasized the extent of control. Again, it was a control analysis and what the NCAA rules impose on the institutions and then are imposed on the athletes. And it's just extraordinary. Some of the same facts that you saw in the Northwestern case. And I want to talk a little bit about the USC case. I'm not going to ask you about anything substantive, but just to do a little compare and contrast with the process and the purpose. So that case, the USC case, is a charge case alleging an actual violation of the NLRA. And that's different from the petition that was filed in Northwestern to unionize. Could you talk a little bit about the difference in those two pathways and the importance of that in looking at the kind of the bigger picture of athletes as employees?
So as we talked about earlier, right, the National Labor Relations Act does not only apply in unionized workforces. And in the petition in the Northwestern case was to seek a union in that workplace, right? But there's unfair labor practice cases that may or may not have anything to do with a formal union. And that's what we're talking about in the USC case. And in fact, if I could take a step back, after the Northwestern petition was dismissed by the board, the Chicago regional office received an unfair labor practice charge against Northwestern, and alleging similar allegations in the USC cases. That is that the student handbook is equivalent to employee handbook, and there were terms in the handbook that were unlawful under the National Labor Relations Act. And we ended up, the Chicago regional office and ended up resolving those cases through a settlement where those unlawful provisions of the handbook were removed. So just again, just that's the unfair labor practice arena, and that is where we see ourselves currently in the USC cases. Allegations of terms in the handbook that are unlawful, as if it would be in any other workplace where you have unlawful provisions in the employee handbook. The misclassification, the classification of these athletes as student athletes, taking them away from the protection of the act being unlawful. And also they're not just the university, but because of the control from the conference and the NCAA, that all three entities should be considered joint employers and severably and jointly liable for the unfair labor practices.
Yeah, I have the charge in front of me. It's just a one-page document. It's very simple, But the charge, the person issuing the charge names Southern California, University of Southern California, the Pac-12 conference, and the NCAA. So that brings in that joint employer theory. And then one of the interesting things about, there's a section entitled "Basis of the Charge" where the movement explains what they're asking for. They land with these rules and policies that you referred to in the handbook that impede free speech and free association and all these values that underlie the legislation in the first place. And I think that's an important discussion because that goes to the fundamental climate and culture and relationship, not just with labor rights, but under principles of basic fairness and open communication. But in this case, in this charge in California, that kind of evidence would be relevant, I guess, in this charge going forward. Is that fair?
Yeah, I mean, I'm just going to be really careful about what I say or don't say about the
So,
active investigation.
Okay, so let's move to something I don't think is controversial, and that's the timing of the process, really. Okay, so
It can be controversial.
we have this charge, and it was filed on February 8th of 2022. Now we have kind of the investigative process. There may or may not be a hearing. This is a different case from Northwestern because it doesn't go directly to unionization. So we don't know exactly what the remedy would look like on the other side. But if you could talk about the process and the timing of it and what the various appeal pathways are, not just through the NLRB, but then into federal circuit court and possibly to the U.S. Supreme Court. And for our purposes, that timing is important because the NCAA and Power 5, they're trying to get protection in Congress on this employee issue. There are 6 bills that have been introduced either in the Senate or the House that address the employee issue. 5 of them would make it that athletes cannot, as a matter of federal law, be employees. And then you have the Murphy-Sanders bill that would do the opposite. So the timing of this is relevant to their campaign in Congress. But if you could just give us kind of the outer limit timing through the kind of administrative process and then the appeal process.
So once a determination is made, and if the determination is that there is a violation of the act, then complaint will issue on the case. Parties will always be contacted to potentially resolve and settle the case, as was what happened with the Northwestern unfair labor practice case that was filed subsequent to the petition being dismissed. So there's always that opportunity. But if the settlement does not take place, the matter will then be set for a hearing in front of an administrative law judge. And once all of this is really, Richard, speculative on timing, because
I understand
how busy the calendars are and the judges, but
it
would be 2 to 3 months from the time complaint issues that the hearing is scheduled.
Okay.
And as you know, litigation, there always is some delay built in to it. Once the hearing takes place, the judge then issues a recommended order, a written order. And that, again, depending on the docket, it may be a couple months, maybe longer before the decision issues. That decision is appealable to the board members. It's kind of similar to our case, but versus it coming from the regional directors, now this is from the administrative law judge decision that is appealable. And that goes to the board. And the board then, acts on it when they can. as soon as they can. And then that board decision can be enforced or reviewed in a circuit court of appeal. And the circuit court of appeal are typically basically, in this case, it'll be depending on who the employer is, it may be more than 2 circuits, but typically the circuits are Washington, D.C. circuit, because they have the jurisdiction over administrative agencies, or the circuit that the employer is doing its business. So this would be in the Ninth Circuit.
Ninth Circuit. Mm-hmm.
But then again, depending on who the employer is ultimately determined, the NCAA is in Indiana. I don't know where Pac-12 is located. Yeah, so the circuits could be at different locations too. Okay. And then the circuit court will issue its decision. It could fully enforce the National Labor Relations Board decision if found to be a violation. Just a side note, the way that the act is written, the National Labor Relations Board's decision, if it affirms the administrative law judge's finding, it's not self-enforcing. They have to have a circuit court to have that enforced, which is why it goes to the circuit court. And then at that point, the circuit court could enforce or could send back to the board with whatever remand issues they may have. If that doesn't take place, if the remand doesn't take place, then of course the parties can file a cert to the U.S. Supreme Court for review at that point. All of that timeline, it could take some time.
Yeah. Talking a couple of years, potentially.
It could take a couple of years. Yeah.
Yeah.
But one thing I will say though, Richard, is that, in the last couple of years, through Jennifer Abruzzo's initiatives and desire to enforce the act according to the mission, even though we're still going through the adjudicative process and we're receiving board decisions and enforcements as we go through the transition, it's heartening to say that employers have been complying. They've been adhering to the initiatives just because I think, part of it, they want to do the right thing, but also this would avoid litigation too. Right. So we've already seen compliance and adherence to many of the initiatives. I'm not saying that there's adherence to this initiative with the athletes, but the process is long and unfortunate, but there are also side benefits to having the initiatives to begin with too.
Right. Right. I want to close this out, Peter, with a question that I think kind of ties into a myth that exists on the athletes' rights side and the athlete side, that there's some magic bullet solution to all of the issues in college sports and the relationship between the athletes and the institutions. And the Austin decision is a good example of that. That was actually a very limited ruling on the law. The unanimity was powerful. But if the claimants in this USC case get everything that they want, that's just kind of the beginning of the process. And once you establish that because you're just trying to get your foot in the door, just to be recognized as an employee and have coverage under the act. Once that's established, and if it isn't overturned, that's just the beginning of the process. And then these athletes would face all kinds of hurdles going forward, and that it's not just going to be a snap your finger moment.
Right. I mean, as we said earlier about it's easy to ignore one employee's voice. It's harder to ignore, two employees' voices.
Right.
But it's still relatively easy to ignore 2 employees' voices. It's hard to ignore thousands of employees' voices. Just to say, hard work really begins after the premise questions are answered on your behalf, because then you need the group action, not limited group action, waiting to see what's going to happen, but group action by employees to demand and seek the terms of work to be changed for the better. So yes, I completely agree with you. And that's not just, as we're talking, not just with student athletes or at the universities. This is across the board in all industries. The hard work really begins once the union is recognized or they are certified. Then what happens? So you seek the improvement. The employees have to work collectively to seek those rights, because it's not going to also magically then become utopia after that point.
Yeah, and I guess I want to close this out with a return to the values. We started with that, and I have to tell you, when I was preparing for this interview, I saw a video that you did. It was like a 2-minute video through the
Mm.
NLRB. And you talked about your personal background and your history and the importance of workers' rights in your life. And you frame those around American values. And I think that in all this complicated discussion about the various pathways and what the law says, what it doesn't say, we lose sight of that. And if you could just kind of close out and talk about how important that has been to you personally.
I mean, I might have mentioned to you, Richard, that, I came here to the United States as a young child from Korea, and we are really a story that you often hear of, which to me, no matter how many times I hear of it, it is still incredibly special. Our family came with nothing, and just the sheer hard work and luck and fortune that we've been able to harness. But with that came, you know, real difficulties, and the imbalance of power clearly demonstrated itself throughout my life. And understanding as I grew up, understanding what it meant at the workplace and the founding principles of what the country is all about, and then understanding how that fits in the workplace under National Labor Relations Act. The symmetries are just amazing, which is why when I have the opportunity, I talk about the fundamental right of association. That itself says everything. The
Mhm.
fundamental right of association that we know so clearly in the Constitution, it is what the National Labor Relations Act is all about. And then from that point, it could be enormous, but the fundamental right of association and the protection to have that is what I find to be so gratifying in the work that the National Labor
Mhm.
Relations Act does. And for folks to understand how that applies to their work, not just to athletes, not just to in traditional unionized workforces, but everywhere in America.
Yeah. And you've dedicated your career to protecting those fundamental liberties, and we thank you for that. So, Peter, I just want to thank you. This has been a great discussion. I think it's going to be really useful, not just for athletes. Our target audience is athletes, but for other stakeholders. And it's a complicated area of the law, but I think it's so important to talk about it on the values level. And I think this is going to be really important for a variety of stakeholders. And I appreciate your time.
Well, thank you very much for inviting me. I really enjoyed our conversation.
Okay, thanks, Peter.
Okay, take care.